Good morning. This is the Cannabis Legal Group. I'm Travis Copenhaver. This is
Nick Melendez.
We're here to discuss marijuana topics this morning. A lot of things going on this week. We're going to start with a little bit of conversation about what we're doing challenging the City of Troy ordinance. Then we're going to talk briefly about industrial hemp and Cbd oil based on an advisory bulletin that came out yesterday and was updated this morning. So to start, we welcome questions. Happy to answer any questions while we're doing this now, and then later if you have comments coming in, please feel free to visit our website. We have our municipality map. Like us and share us on YouTube and our link on the channel here, and we look forward to engaging you guys both now and in the future. So Nick, let's get right into it. What exactly is going on in the City of Troy?
Right, so we filed lawsuit against the City of Troy based on an ordinance they recently passed. Just to kind of give a little overview first, since 2008 the city had been issuing certain approvals, both building permits and certificates of occupancy, to caregiver tenants and the property owners who were leasing these spaces to those caregivers for the purpose of engaging in medical use of marijuana cultivation for their patients under the Michigan Medical Marijuana Act. So they've been issuing about a little under 80 of them since then, and a little bit ago, a little bit earlier this year, they opted out of the MMFLA.
Okay. Before we move on from that, so basically these are for caregivers that are wanting to grow in like non-residential locations, correct?
Correct. Yeah.
Okay. And that was something they were allowing for a while, and then they passed an ordinance basically changing those rules. What changes were they trying to make?
Well, I think, a lot of people, since they were allowing caregivers to do this, thought that maybe Troy would opt into the MMFLA. And so a few months ago, they ended up making a decision 4-3 to opt out. Then a few months had passed, and they decided to pass what they call the Medical Marijuana Caregiver Grow Operation License, which requires all of these existing facilities and any other caregivers in the city to apply and obtain a license from the city. It basically conditions the caregiver's ability and patient's ability to cultivate medical marijuana in the city on obtaining a license and meeting certain criteria that we believe is very restrictive compared to the Michigan Medical Marijuana Act.
Okay, can we go into some of those items that are restricted?
Mm-hmm.
Okay.
Well, definitely, I think that they are restricting the locations. They're zoning them only in industrial areas. And making them be certain distances away, whereas the MMMA only requires you to not cultivate in a school, bus school, or correctional facility. And
some of those locations are excluding areas where caregivers had previously been, given some allowance to cultivate.
Yeah, and actually the ordinance is restrictive to the extent that if you're a caregiver living in the City of Troy, you're not allowed under the language of the ordinance to cultivate in a residence. If you're a patient, you're allowed to, as long as you're the only patient in that household. So if there are two patients, for example, living in the same household, the language of the ordinance would require them to get a license, pay a licensing fee of $1,500, disclose patient information if you're a caregiver living in your house.
All right, we're going through a lot of things very quickly. Let's try to break them down in smaller bits to talk about them so we don't just blow through them all.
Mm-hmm.
Okay, so basically what Troy's new ordinance requires you to do is basically identify yourself as a patient to the City of Troy and get a license.
Yeah, or as a caregiver, and then also just...
But those are for residential locations, right?
Even, yeah.
I can understand how that makes sense at a non-residential location, but at a residential location, they're not allowing caregivers to cultivate residentially without permissions, or just not at all?
Not at all, under the language of the ordinance. And then as far as patients go, you're either a one patient and you have to satisfy their home occupation ordinance, or if they're more than one patient, you have to obtain a license.
Okay, so effectively, even though state law says you can engage in the medical use of marijuana, as long as you're not doing so in a school bus, correctional facility, or on the grounds of a school, the City of Detroit is going above and beyond and saying caregivers specifically cannot engage in that legal conduct in the City of Troy unless they do so in a very specific way. Mm-hmm. All right? And then patients who are also allowed to cultivate on their own, should they so choose, are restricted in the City of Troy from cultivating if they happen to live with another patient. Yes. Is that accurate?
Mm-hmm.
Okay. So that's for home cultivation. So not only are there some additional restrictions we can get into on non-residential locations, but there are restrictions in place based on what you can do in the privacy of your own home.
Correct.
Okay. So let's shift gears and talk about industrial commercial locations. Mm-hmm. So the reason a lot of caregivers and patients perhaps are going to want to move cultivations into a non-residential location is because, quite frankly, if you're growing up to 72 plants, it might not be appropriate to have that set up in your home. A lot of people look to a more secure off-site location to do so that they can not only cultivate efficiently and safely, but they can actually create products that are, appear to be a bit more medical than they could be growing in a basement or a garage or something like that. So before we start talking about the issues we have with it, let's talk about what the City of Troy's ordinance is requiring people who want to cultivate in a non-residential location. What are the rules of this new ordinance setting out?
Well, it's basically, if you take a look at the ordinance, what it does is it almost takes some of the licensing requirements under the MMFLA and tries to impose them on individual caregivers.
How so?
Making them submit to a background check, putting restrictions on them as far as if they have any felony or any misdemeanor, that's subject and grounds for the city to deny them the ability to cultivate, which under the state law, the MMA, there are certain, that's more restrictive than what the MMMA allows. And obviously, these caregivers have submitted applications to the state, have been issued their registry cards, and, in the state size, they're allowed to cultivate, and, state law trumps local ordinance when it conflicts, and so that's one of the biggest arguments.
All right, so what kind of things do they enumerate what's in the background check? Because, under state law, it clearly says what the 3 requirements are to be a caregiver, whether or not you have a certain felony, if you are 21 years or older, and you decide you want to do it. Are there additional factors that the City of Troy is concerned about that they decided to enforce above and beyond what the state law clearly defines?
Not with respect to the background checks, but certainly, there's another kind of condition in there where you have to provide emergency contact information to the city, and if you don't respond within 15 minutes, they're allowed to enter the facility, and more or less that could be grounds for them revoking your license. And so there's definitely certain things in there where they're definitely overreaching based on case law and based on just the plain language of the Michigan Medical Marijuana Act.
Okay, so how about location-wise then? So you said that there's some now location restrictions, which those are the types of restrictions and ordinances that can be in some cases appropriate. I think the issue in Troy is we had caregivers that were previously given certificate of occupancies for certain locations that are now not included in the new ordinance. Is that correct?
There's a certain deadline by which they have to apply, which is June 15th. Also, there's certain arbitrary language in there as far as these caregiver tenants, these property owners that were issued certificates after January 1st aren't able to apply early. I think a lot of the temperature is that they were pulling the rug out from a lot of these places, as we were talking about the amount of investment to make these places safe for the caregivers to grow and time into the buildings, to have the rug pulled out from under you. And then, all of these were located in the industrial district, the industrial integrated business district. But now there's 1,000 feet, buffer from schools, colleges, universities, libraries, playgrounds, those types of things, which they try to couch in federal law.
Okay, got it. So I guess the takeaway is, as we discussed in our last video, the 2008 Medical Marijuana Act patient caregiver system has not changed in any way. The Medical Marijuana Facilities Licensing Act of 2016 creates a new type of conduct to engage in medical marijuana for licensed businesses. And the lesson should be, if you're a municipality, you can't impose the restrictions of one law on the operators acting under the scope of another. What you're allowed to do for MMFLA applies to people participating in the MMFLA. What you're allowed to do under the MMMA applies to participants who are operating under the MMMA. And the issue in Troy is it's the starting to butt heads with, you're putting some of these restrictions that you could have implemented against an MMFLA applicant and trying to place them upon a patient or a caregiver. Patients and caregivers just, quite frankly, have a different set of rights and restrictions and requirements that aren't necessarily appropriate to impose upon them the way you could on an operator under the MMFLA, which is a business deciding to participate in a known set of, restrictions. They know they're subject to a background check. They know they're subject to capitalization. They know they're subject to the narrow definition of the license they're seeking. Whereas a patient or a caregiver has, quite frankly, rights to privacy, rights to confidentiality. Caregivers are allowed to help up to 5 patients. No municipality has the right or any reason, quite frankly, to need to know who those people are. If the caregiver has cards and they're valid cards, that should be good enough to allow that caregiver to engage in conduct, and it is under state law. So I think a lot of the challenges that have been brought up and the way this conversation is going to go is just to be very, very clear. Just because we have new medical marijuana laws and we might have a new one in November and things are changing, that doesn't mean you can attack and narrow the rights that have been imparted to people who are lawfully participating under the 2008 MMMA.
And I think it's important to note, the MMMA says that a patient or caregiver shall not be denied any right or privilege, isn't subject to arrest, penalty from a licensing board or professional licensing bureau for the medical use of marijuana. And, all things that conflict with that do not apply to the medical use of marijuana.
That's my favorite section, Section 7. And if you ever have an issue like this, that's the first place to look. All other acts inconsistent with the MMMA do not apply to the medical use of marijuana. And as we said last week, the medical use of marijuana is not only the consumption by a patient, but the cultivation of marijuana by either a patient or a caregiver. So.
And that's, I think, you already touched on it. The stark difference between the MMMA and the MMFLA is that the MMFLA gives every city, town, or village the control and the means by which to regulate this in a reasonable way. The MMMA has fewer of those provisions in it that grant local authority in terms of restricting or prohibiting or conditioning the medical use of marijuana on X, Y, and Z.
Right.
And I think that's what we run into.
Now we've been talking a bit specifically about Troy, but I'll reiterate again, like we said last week. What cities and municipalities can do does involve things like zoning, does involve things like inspections, especially for non-residential locations. So this is not to say that a city is prohibited from having some sort of ordinance in place that might speak to what patients and caregivers can do within the jurisdiction of that municipality. But any such requirements need to take in mind and be reflective of what is allowed under the MMMA. Anything else about Troy you want to bring up while we're talking about it?
No, I think we did a good overview
So
cover everything.
We'll probably be checking in as that continues to move forward. The other item we are going to be talking about today is an advisory bulletin issued by LARA yesterday. It was updated this morning. It regards CBD and industrial hemp. And it's more of a clarification of what the laws are and how we can expect the state of Michigan to deal with those two items as we move forward, as laws continue to change.
And I was going to say, this is one of the even more complex gray areas with respect to federal law and state law and different definitions.
Right.
There's a lot of different interpretations going on. So, if you can, you want to go ahead and
and
describe
if you think,
CBD, describe hemp, and kind of go.
And if you think the Medical Marijuana Facilities Licensing Act is complicated, then you should really take a deep dive into the status of hemp in the United States. It's probably the most complicated cannabis marijuana adjacent related topic, at least in my opinion. So to start, industrial hemp, we have allowed in the United States to certain degrees in a very complex way the importation of what we call hemp. The difference is between hemp and what we would refer to as marijuana or cannabis all comes down to the percentage of active ingredients within that plant. If a plant, has 0.3% or more of THC, it's considered, a controlled substance, and if it does not, it's considered hemp with some exemptions applied. Effectively, if it's the mature harvested stalks of a hemp product, or it is the sterile seeds or derivatives thereof, it can be considered hemp, and we've been importing hemp in the United States for a long time. So more or less that's what hemp is. Hemp is allowed to be cultivated in the United States under what we call the Farm Bill, and it's been updated a few times. In Michigan, we do have industrial hemp research that is allowed. It's either allowed through the state of Michigan or through educational institutions. It's not something that can be privately done at this time. But industrial hemp that is legally cultivated in Michigan is purely for research purposes, more or less. It's not allowed to be turned into some sort of commercial product. Other hemp is imported for a variety of, textiles, plants. I mean, you probably had hemp seeds in your bird seed forever. And don't worry, I'll get to CBD in a minute. But specifically for hemp, that's more or less where we are in hemp. And hemp's going to be a discussion topic moving forward because at the federal level, Mitch McConnell is working in a definition change to some of the laws that are pending at the federal level to basically exclude industrial hemp from the definition of the Controlled Substances Act and allow more United States focus on the cultivation of marijuana and making that a little more federally legal than it has been. Also, keep in mind that industrial hemp at the state level is a part of the ballot initiative we'll be voting on in November. So just like we'll be opening up the cultivation of medical marijuana under the Medical Marijuana Facilities Licensing Act to the different businesses here, should the adult use November ballot pass, industrial hemp will now be at the state level, something that will be allowed, like we see that in other states like Colorado, California, and some places. But at the federal level, the definition of industrial hemp is very narrow, and what you can and can't do and who can cultivate that is the same sort of federal challenge that you'll have for medical marijuana as well. You know, a lot of the products people want to engage with and consume or manufacture do fall under the Controlled Substances Act. The difference between medical marijuana, which is very clearly a controlled substance at the federal level, and industrial hemp is, you know, depending on the part of the plant we're talking about and the percentages of active ingredients, there are ways that hemp-derived products can fall outside of the prohibition in the Controlled Substances Act. So that was probably very confusing. I'm a little confused, quite frankly, how industrial hemp works, but hopefully that was a basic primer. CBD oil is very related to this conversation because CBD oil is a non-psychoactive, intoxicating element of the cannabis plant. It is something that a lot of people are using for a medicinal purpose. It has a lot of implications at the medical side of things, and it has traditionally, in the last several years, fallen into a more gray area than THC and flower and medical marijuana products. And you do see CBD oil and CBD products being sold, you know, in more ways than traditional marijuana is going to be allowed. You'll see it in health food stores, you'll see it online, and you do see it around to an extent where it's less clear that this is a federally illegal product. The problem is, at the federal level, the CBD oil is considered a controlled substance the same way any other cannabis product is. And then the conversation then becomes complicated because, technically speaking, there are legal hemp products that can be imported into the United States, and technically you can derive CBD oil from those legally imported products. I think the problem becomes, just because that's technically possible, in reality, very few CBD products are made that way. Most of the CBD oil that's manufactured is usually derived from a type of plant that is very clearly a controlled substance, and then the resulting product might not have THC in it, but it came from a plant that would fall under those federal restrictions.
Right, and I just want to say, I think the issue too of it is that it's hard for, say, the DEA or law enforcement to really make a distinction between CBD that's extracted from the part of the plant that would be considered a controlled substance versus the one that is considered legal under the definition of the term.
So as we are getting businesses set up to engage in the medical marijuana industry in Michigan under the MMFLA, we're going to have growers that are growing products, processors that are creating products that are very clearly federally illegal until those laws change. They are legal at the state level under the MMFLA as long as you are operating under the scope of a legal license. Now, because CBD oil is possible to be created in a legal way, it is important to understand that the federal definition of marijuana basically still makes that an issue. I'm not going to get into the specific language, but the way it is laid out, and again, like I said, it's a little complicated, but the way they define marijuana is all parts of the plant are a controlled substance, and then there's an exception that says certain parts of the plant, if they fall under the definition of hemp, aren't a controlled substance, but if you do extract and make certain derivatives of those exemptions, they can come back into and be treated as a controlled substance.
So it's like almost like two negatives make a positive.
Right. It's
so
an exemption
one
to an
thing that's
exemption.
prohibited, another thing that's an exception, but you do that extra thing to it, and it makes it fall under the definition of a controlled substance. So you have to have.
So effectively, the default position is it's all a controlled substance. There's a carve out for hemp products, for things like shirts and birdseed and hemp bars, the sterilized seeds and things you'll see in health, health products and things of that nature. But if you read the the next part of that definition of cannabis at the federal level, it says extractions and derivatives, salts, and things thereof are considered a controlled substance again. So again, that's all very, very technically complicated, and it makes the whole CBD conversation, quite frankly, a very difficult to parse situation. And you see different states have different opinions on it. Different law firms, quite frankly, have different opinions on it. And CBD is almost as complicated as industrial hemp is. So what the state of Michigan is doing in this advisory bulletin is effectively making its position clear.
I think what they did was, a lot of people were probably asking, can I sell this? Will I be able to do that with or without a license? And LARA wanted to provide the clarity to everyone during this period before licensed facilities are up and running, just to kind of give a direction for everyone to go in. So based on this advisory bulletin, they released it yesterday, they revised it a little bit today. The most important takeaway of it is the bold lettering on it. It says the possession, purchase, or sale of marijuana or any marijuana product, including CBD, must be done in compliance with the MMMA and MMFLA.
Right. I mean, just from a safety standpoint, if you are a user of CBD or if you are a retailer of CBD or a manufacturer of CBD products, whether or not you're technically doing something wrong is an argument that can be made. I think from a practical standpoint, you should be careful about what you're doing right now, as our laws are being figured out at several levels of enforcement. The state of Michigan is effectively, giving you notice that there are probably CBD products out there that they're going to consider medical marijuana. Now, if you are a patient and lawfully allowed to possess and consume those products, then it really doesn't matter. But if you're not a patient and you're not a caregiver, the possession and sale of CBD products might be called into question. Now, there are some cases talking about what about CBD oil that is being derived from more lawful sources, and I think that's a dispute that's going to be happening at a national level. In California, there was a case pending about how hemp was going to be treated under this definition, and the hemp industry effectively was challenging the Department of Justice, the DEA's interpretation of what hemp products were and what CBD products were. There was procedural reasons for this, but that case did not go in the hemp industry's favor. And that was in the Ninth Circuit. I believe we'll be issuing an article talking about CBD in more depth on our website fairly soon. But the fact of the matter is, from just a practical standpoint, the legal status of CBD is to be determined. So if you want to be cautious and safe, if you are not a patient or a caregiver and you want to or you do rely on CBD, it might be time to talk to your physician about becoming a patient if you truly are using CBD for one of those qualifying conditions.
And I also think, too, from the state standpoint, they're here to protect the public health, safety, and welfare. And, from what I've seen, there's been issues with certain CBD oils and products where they aren't tested, they aren't regulated. The same with marijuana products now. We're trying to get that into a regulated, licensed, tested, safe industry. And so I think this was the best way that the regulators might have saw to allow this to be safe for those people who are allowed to do it, and then subject to federal or state law being changed to allow it in a different way. But certainly there's testing concerns, safety concerns. You want to make sure it's from a reputable source and it has what it says it has in it. And I think that's also a concern that the LARA was concerned about.
Right. And to be clear, if we do pass the November ballot regarding medical marijuana and regulating it closer to alcohol, clearly then CBD products that are available for sale in the state of Michigan, at least under state law, will be just as legal for adults 21 years of age or older to purchase the same way that if any of those products happen to have THC concentrations in them. So, while CBD at the national level is still a conversation that's being had, while locally, in the short term here, CBD's legality in the state of Michigan might be called into question. One of the ways to ensure CBD is something you can consume legally even if you're not a consumer of other traditional marijuana products, THC heavy products. If you do find value from CBD, that's another great reason just to support the November ballot and give yourself the legal opportunity to use those products in the state of Michigan. You should still be cautious should you want to take those products out of Michigan, regardless of what our laws are, until the federal status of those products are more clarified and you know what is and isn't safe from a legal perspective.
I was going to say we have a few questions.
Yeah.
In terms of, we're not going to be able to give legal advice whether it's safe or not to take it off the shelves and kind of giving any advice on whether we think there's going to be more or less enforcement. But I did want to answer Brad's question as far as the initiative coming up, whether or not there will be a shift in applicants. And I think we touched on this a little bit before. I don't think there's going to be a shift in those waiting, unless you're a Michigan resident or a medical license, state operating license holder. You don't get first bite at the apple as far as recreational licenses. So I think there will still continue to be an influx of applicants applying under the MMFLA to get that license, so that when the framework and application process comes online for the adult use facility licenses, they will be able to apply rather than just kind of waiting it out. Because if they wait it out, they'll won't be having as many licenses available for them. That's
right. Cassandra, I'm not going to answer your question directly, but I will read the bold section of the advisory bulletin for everyone's benefit here. The possession and purchase or sale of marijuana or any marijuana product, including CBD, must be done in compliance with the Medical Marijuana Act and the Medical Marijuana Facilities Licensing Act. You want to take Wendy's here?
As far as stepped up enforcement, I think that just kind of goes along with what Travis was saying. Just reading that, what the MMFLA allows visiting centers to do is sell certain marijuana and marijuana products whether they have a license. And so there's certainly some caution there if you're doing any of that without a license.
Right. So, just to kind of close here, because we do try to keep these close to half an hour, we're happy to jump in the comments section afterwards. So if you have questions and digging them in, we'll do our best to answer all those that we can. Obviously, we are a changing landscape in the state of Michigan, and it's not going to be necessarily a perfect road forward. As our laws change and allow things to become more and more legal for cannabis, regardless of we're talking medical, recreation, CBD, industrial hemp, it's important to be careful and not get caught up in a dispute over something that might be something that isn't a factor in a few months once things settle. So, we are implementing the Medical Marijuana Facilities Licensing Act in the state of Michigan for the first time. To date, there are no licensed businesses. Is that going to be jarring and create some problems for patients waiting to rely on those businesses? Of course. Just like states where medical marijuana in general just isn't allowed at all, it'd be great if those patients could start smoking marijuana sooner rather than later. And we have a different scenario in Michigan because under the MMMA, you can at least cultivate yourself or find a caregiver to do so for you. So at least, as we're changing from what we used to have into this new program, there's at least an option. Is it a good option for everyone? No. But it's better to do what you can and stay safe than have a legal issue because, the industry didn't move as fast as you needed it to. And that's kind of the same approach that we need to take for industrial hemp and CBD as well. Well, personally, I think both are great and they should be implemented as soon as possible. That doesn't mean I'm going to go out there and plant a field of industrial hemp until it's legal because obviously I'm going to be putting myself at risk. So if you do want to engage in the use of CBD products or the sale or transfer or cultivation or manufacturing of, you need to be careful and do so carefully. And if you have questions about whether or not what you're doing is something you should be doing, it might be time to reach out to your personal attorney about what you're trying to do and what you should be worried about. So.
And I think the best way to do something if you don't agree with the laws is to be active, to vote, contact your local congressman and the legislature, and just really try to have your voice heard.
And LARA too. I mean, we've mentioned this in several videos. They are receptive to public feedback. Now, they can only do what the law allows them to do, so they can't change the laws. They have to enforce them and implement them because that's their role. But both at the Bureau of Medical Marijuana Regulation, LARA as a whole, and then our elected officials, reach out to them, tell them how the decisions they're making are affecting you, and if you have suggestions for how they can be doing it better, now is the time to tell them because we are rolling out a new program. We'll be rolling out hopefully an even newer program in November. And it's time for this industry, if you're an advocate, to be active in, in telling them what they need to know to make sure they do it correctly. So, anyway, for Travis Copenaver and
Nicholas Guendes,
thanks for talking to us and hanging out today, and we'll catch you next time.
See you.